State, are you ready to make an opening statement?
We are, Your Honor.
All right, you may proceed.
Good morning, ladies and gentlemen. As we spoke about a number of days ago, we talked about the role of a juror. And a role of a juror during what we call the guilt phase is the same rules that will apply to you during this penalty phase. The role of the fact finder and the law applier are still relevant in this portion. But as it comes to being the fact finder, the state has presented to you in great detail a number of the facts upon which we are going to rely upon in asking you to find the existence of an aggravator. All right? You've heard the testimony from the medical examiner, Dr. Palma. We spent a great amount of time talking about the nature of the injuries, the circumstances of the injuries, the photographs as it relates to those injuries, and to his observations and as to his opinions as it relates to those injuries as to each victim in this case. We are going to be presenting to you again, Dr. Palma, to add just a little bit of testimony for the purposes of the record. He's going to explain to you primarily that with each impact of blunt force trauma as it relates to Margaret Brown and Nicholas Leonard, that with each impact and with each strike, there was impending pain and bleeding associated with that. Now, the evidence does kind of bear that out, but for the purposes of presenting a complete record to you, we're going to add this element of pain that would be associated with the blunt force trauma that these individuals felt. In addition to that, Dr. Palma is also going to talk about the nature of the injuries related to Gregory Brown. If you take his testimony in light of what the defendant testified about, there is a period of time between the injuries that Mr. Gregory Brown sustained. The circumstances that led up to his death, meaning what he had in his mind and the knowledge of the attack as it relates to Nicholas Leonard, as the impending injuries that could have been sustained to his daughter Megan Brown, the fact that he was shot in the back, hit his iliac bone, causing it to shatter. You've seen the pictures, that there is, in fact, pain associated with that. And that's something we're going to ask you to consider. But more importantly, that is not an injury that would have led to his immediate death. That there would have been a period of time that he would have laid there on the floor in the master bedroom closet. And that associated with that time, as the defendant already testified to, that, as the defendant said, he walked up and shot him one more additional time. That there is, in fact, time of conscious thought that Gregory Brown would have had in that closet. And it is that thought of impending death, not only as to himself, but as to his daughter, Megan Brown, who would have been alive at the time, are some of the facts that we're going to ask you to consider in aggravating this crime. We're also going to present to you a witness that you've already heard from, Mr. Jimmy Sigler. Mr. Sigler is an associate or friend of Nicholas Leonard and the owner of the bar in which he frequented. Now, you've heard testimony and you've seen, and just so that we're clear, all the evidence that's come in through the guilt phase is evidence that's relevant to this portion of the proceedings. And the fact that we don't specifically talk about a certain piece of evidence or highlight it for you is really because we've taken the time in some in great detail to show you. So you should consider all the evidence in this case. But as it relates to Mr. Sigler's testimony, that you're aware that there was a 911 call on the morning as it relates to Megan Brown, and that because of that call, and you can hear her emotional nature on that call, that she calls out of work, and that there is conversation at least between her and the members of the place where she worked, the Fisherman Shack. You're going to hear from a text message chain where it originates from Megan Brown as it goes to Mr. Sigler. All right, and we're going to present to you some evidence as to what she is saying to Mr. Sigler. And what you're going to hear is that during the course of the day, as the defendant's not at the house, that there is a chain of conversations that you'll get to hear that really go to what her mindset was during this pending of time between the 911 call and her ultimate death. And you're going to hear and read through these text message chain that she was in fact afraid of the defendant coming back to finish her off. All right? and that this level of fear and this level of concern weighed on her. All right? And this level of fear is something that you can take into consideration when you are trying to determine whether or not this is an aggravated case. The fact that she is aware and that she is concerned, and that throughout the entire day that this level of concern affected her and emotionally and mentally. We've talked, and the court's kind of mentioned in the preliminary instructions that there is a procedure as it relates to that the jury has to follow. And one of the things, the first thing that we have to prove to you is whether or not the state has proven at least one aggravating factor beyond a reasonable doubt. Well, in this case, the state has listed and placed the court on notice of two aggravating factors upon which the state seeks to prove to you beyond a reasonable doubt. The first aggravating factor which we seek to prove to you beyond a reasonable doubt is what statutorily, meaning in the law as it's written, is called that the defendant has been previously convicted of another capital felony. Previous conviction, another capital felony. All right? We're going to present to you some evidence by way of the judgment and sentence which will relay back to you the fact that you guys have come to a verdict in this case. All right? A previous conviction for another capital offense means that before today's proceedings, Mr. Matos has been convicted of a previous capital felony. Well, in this case, the state has alleged 4 counts of murder in the first degree. You have found him guilty of all 4 counts of murder in the first degree. A previously convicted of another capital felony, as the statute lays out, can mean a multiple murder scenario. All right? Although all of these homicides occurred on the same day in a general time frame with each other, the fact that he's been convicted of them all, one can aggravate the others. So, for example, the fact that you have found him previously guilty of murder in the first degree as it relates to the homicide of Nicholas Leonard, the fact that he's also been convicted of murder in the first degree for Megan Brown, Margaret Brown, and Gregory Brown, those convictions can aggravate the other conviction, okay? The fact that they all happen together, contemporaneous with each other, is an aggravating factor in this case. And I'm going to suggest to you, and we'll argue to you later, that your verdict has found that beyond a reasonable doubt. But just so that we're clear, although they were all tried together, and they were all presented to you together, you're going to individually come to a verdict as to each count, okay? So count 1 can aggravate counts 2, 3, and 4. Count 2 is aggravated by counts 1, 3, and 4, and so on, all right? The law allows for the aggravation for multiple murders contemporaneously occurring at the same time, all right? The law will also explain to you that murder in the first degree is a capital felony, but that's kind of why we're here. The second aggravator of the state is going to prove to you beyond a reasonable doubt is one that the murder in the first degree was especially heinous, atrocious, and cruel. All right? The court will instruct you on the law as to what these things mean, what a heinous means, what atrocious means, and what cruel means. The court will instruct you that heinous means extremely wicked or shockingly evil. And atrocious means outrageously wicked and vile. And cruel means it is designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. All right? So when we get to this aggravator of heinous, atrocious, and cruel, I'm going to ask you as the jurors to reflect back on the evidence that's been presented in this case. All right? Specifically, the testimony of Dr. Palma, as he relates to the injuries and the nature of the injuries that they sustained, as it relates to Anna Cox, the blood spatter expert that really kind of put together the DNA test evidence and the blunt force trauma evidence and the crime scene evidence. We're going to ask you to relate back to that. And when you look at those evidence, that's where you're going to come to whether or not this was a especially heinous, atrocious, or cruel murder. Now, this is going to be true for all 4 of the victims in this case. We're going to ask that you look at each aggravator as to all 4 victims, and we'll present to you an argument why we believe those aggravators apply to each one of the 4 victims. It's a slightly different set of facts as to each one. We ask that you keep an open mind as it relates to the evidence as it relates to the heinous, atrocious, and cruel. Again, just to kind of outline, Judge, if I may see the verdict form. Just to outline the decision making that the court is going to present to you at the end of the presentation of both the aggravators and the mitigating circumstances in this case. We will also present to you a single closing argument as it relates to why we believe these things have been met. But there are really 4 areas or sections as they're related to. I just want to briefly describe that for you so you have a better understanding of the framework upon which your decision is going to be made. As to Section A is the existence of an aggravating factor. In this case, your jury will have to come to a unanimous decision as to whether or not the state has proven at least one aggravating factor to you. And those aggravating factors, as I've outlined for you, are going to be: was he previously convicted of another capital felony? And I'm suggesting to you that you're going to look to the evidence that we presented to this and your decision that you made in the previous penalty phase. In addition to that is whether the first-degree murder was especially heinous or cruel. You're going to be given a yes or no question as to each of these, and you're going to have to make a decision. If we have proven at least the existence of one of those 2, then you will move on to Section B. Section B is whether or not the aggravator that you have found unanimously to be proven beyond a reasonable doubt is sufficient to warrant the death penalty. That's where you will sit as a juror and decide whether or not these aggravators, as it relates to the circumstances of this case, as to the evidence that's presented, and in light of the testimony of the defendant, is sufficient to warrant a death sentence in this case, or one that would be life in prison without the possibility of parole. If you find that we have proven that to you unanimously beyond a reasonable doubt in Section B, you'll check yes, and then you move to the next section. The next section is called the eligibility for the death penalty. And this is where we've kind of engaged in some discussion about weighing of the aggravating factors versus the mitigating circumstances. And the court's going to instruct you on the law as it relates to that, and that's going to be, and they're going to tell you that basically it's not a mathematical or scientific weighing. It's really up to you as jurors to look at the evidence in this case, compare the aggravator to the mitigating circumstances that have been presented. If the jury finds that the aggravating factors that have been proven to you outweigh the mitigating circumstances that have been presented to you, then you would check yes in Section C, and then you would go on to the final section. Section D is this is actually where you would come to your decision as to whether or not, based on the facts of this case, the circumstances, the testimony, the aggravating factors, and the mitigating circumstances, whether or not this case is a death penalty case. And basically, the question is being presented to you, having found the existence of at least one aggravating factor, that the aggravating factor is sufficient, that the defendant is eligible, that the jury would then have to unanimously, again, that means that you all must agree that the death penalty is the appropriate sentence in this case. It'll be pointed out to you, I imagine, a number of times, that in all these decisions that you have to come to, they have to be unanimous. All right? That means you all have to agree. And we spent a fair amount of time in the beginning of this case talking about things that related to the death penalty upon which you probably never thought about before walking into this courtroom. Things like that the death penalty is not required in any case in the state of Florida, and that it requires, in a lot of these decisions, it only takes one person to say, listen, I don't think that based on these aggravating factors or that it's either sufficient, eligible, or even warranted in this case. But as you sit here today, the evidence that's been presented to you through the testimony, the physical evidence, the defendant's own testimony, is that you're not in the same spot that you were when you came into this courtroom and started hearing about the facts of this case. You have learned and you have seen through the presentation of evidence and through the testimony that this is a case for which the state believes is especially aggravated because of the prior violent felony convictions and because of the heinous, atrocious, and cruel nature, the evidence that we're going to present to you in this case. At the conclusion of the testimony today or even tomorrow, you're going to have an opportunity to go back and make a decision as to the facts of this case and what is the appropriate sentence. And when that is done, we're going to ask you to return a verdict as to each count of this case, as to each conviction that you returned, that the death penalty is appropriate in this case because of the aggravating natures and the prior violent felony and the heinous, atrocious, and cruel nature of it. Thank you.